Go this way. Let's read this here. Now, of course, I'm not going to read all of it, but we do want to look at some of the important parts, namely the part about June 7th, that ex parte meeting. Let's see. Schardt motion is spicy. Apparently, Love lied to get the meeting, stating Woody spoke with the defense attorneys. Oh, yeah, that's a fact. I read that. It was crazy. That was crazy. Let me see something here. Now, let's get into it a little bit. Um, Now, here's what Shannon Stillwell filed with the court. Renewed motion for a fair and constitutional trial and appropriate remedies for constitutional violations. So remember I said that? He asked for remedies, but he didn't say specifically what he was. Well, I guess he did kind of lay out some remedies at the end. Okay, let's get to it. K-Way said, I said when Tick took the stand, he set the tone and the state thought these boys was dumber than they seemed. Oh, that's facts. That, my commentary on Tick is what actually helped my channel be propelled as one of the ones that people check out when it comes to this YSL trial. Of course, we're not one of the top channels, but my Tick commentary is the one that, because I put out there that he was a genius, because remember, it was really going viral that he didn't know his age, and he was like, oh, they was feeling bad for him, like he's ignorant. I was like, oh no, he's a genius. Y'all just don't know what's going on right now. And it turns out, and I told him that pretty much everybody who's going to testify after that is going to follow Tick and do what he does. And here we are. Now, renewed motion, okay. Now comes now. Shannon Stillwell, by and through undersigned counsel, and hereby files this renewed motion for fair and constitutional trial in the above style case. In support of this motion, Mr. Stillwell shows as follows. Background facts. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the Georgia RICO law and substantive felonies. Mr. Stillwell is an innocent man. Like all citizens, Stillwell is guaranteed a fair trial and due process by the federal and state constitutions, the Confrontation Clause, the Due Process Clause, and all other constitutional protections. We can scroll through that. They're just citing. Stillwell and his co-defendants have been in trial for approximately 19 months. Approximately 75 witnesses have testified so far. Stillwell has remained in jail for the duration of this trial. Glanville was the original trial judge. Glanville was recused from this case, by Krause on July 15th. The state is seeking life without parole sentence for Mr. Stillwell if he is wrongfully convicted. Mr. Stillwell demands that his trial be conducted in a fair and constitutional manner. The prosecutorial misconduct implicates a criminal defendant's due process rights when it renders the trial unfair and violates the defendant's rights to a fair trial. Due process also requires Mr. Stillwell to receive a fair trial in front of a fair tribunal. Judicial integrity is a state interest of the highest order because the power and the prerogative of a court to resolve dispute rests upon the respect accorded by citizens of a court's judgment. In turn, depend on the issuing court's absolute probity. Now, of course, I'm reading through, I'm not reading the case law that's being cited because I'm not doing that. To the extent that this trial has failed to meet these constitutional requirements in the past, Mr. Stillwell demands that the court take appropriate action. Mr. Stillwell is confident that the court will endeavor to ensure him a fair trial moving forward from the current trial judge. This does not cure the constitutional errors and the resulting harm, Mr. Stillwell, which has already occurred. Now, readily apparent examples of error and propriety, prosecutorial misconduct, and judicial partiality. The case has been plagued by discovery violations, lost and missing police reports, and Brady violations, which should have already gotten a mistrial, right? As detailed in co-defendant Williams' July 10th motion for mistrial, the prosecutors of the case repeatedly, and that's a little typo right there. You got to be sharper than that, buddy. Repeatedly failed to follow the orders of the court that have made specious allegations against defense counsels and have lacked candor to the court. So they just keep lying on us. This case has been plagued by improper legal rulings, including but not limited to an overly liberal, unconstitutional application of 801D2E. Defense counsel has repeatedly been cut off by the prior trial judge while arguing these matters. Rulings have been made with little or no analysis. No, Judge Glanville was taking complex motions and denying them within seconds of the person who made the motion saying it. Crazy. This case has been exceptional in the treatment, actually mistreatment of defendants and defense counsel. Examples include, but are not limited to, an incident which occurred on or about October 2nd, 2023, when Glanville initiated a contempt hearing against undersigned counsel Max Schardt, attorney for Mr. Stillwell. On this date, Glanville sent deputies to find undersigned counsel during the court's lunch break and summoned undersigned counsel to chambers. A court deputy informed undersigned counsel that Glanville was expecting an apology from counsel for calling him some bullshit in open court. While in chambers, undersigned counsel was advised that he should not deny the allegations, and it was captured on video. They love to say it was captured on video out that courtroom, right? When undersigned counsel refused to apologize for something he did not do, Judge Glanville tersely instructed counsel to leave his chambers. Later in the day, Glanville initiated a contempt hearing against undersigned counsel. Glanville berated counsel and threatened incarceration. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. Glanville was actually wild. In the end, attorney David Botts, who was seated within feet of undersigned counsel at the time, spoke up and stated undersigned counsel never made such a statement. Of course, that video that captured the event was never produced and no apology was made. Judge Glanville repeatedly demanded that certain defense counsels, including but not limited to the undersigned counsel, attorney Brian Steele, I'm guessing it was that Carlton Matthews, supposed to be Carrington Matthews, to sit down in a terse and abrupt manner when overruling valid objections all in front of the jury. These incidents have been too numerous to document individually. Glanville has sustained specious and frivolous vagueness and facts not in evidence arguments from the state that has effectively cut off the defense's ability to conduct thorough and sifting cross-examination. Just one example of this can be found by viewing undersigned counsel's attempt to effectively cross-examine investigator Tyrone Dennis. I think the Dennis one was, if I'm not mistaken, that's the one when they kicked the jury out and he told Schardt, like Schardt was up there, he told Schardt, hey, if you insult somebody else's intelligence up in here, you will have to see me. I think that's what he's talking about right there. And Schartt's like cross-examination was pretty much cut short from that. He just was thrown off. Glanville on two separate occasions baselessly called attorney Brian Steele unprofessional and unprepared in front of the jury. When it was shown that the Judge Glanville's comments were completely off base, Glanville refused the defense request to issue an instruction that the jury should disregard his comments about Steele. Glanville has monitored the movements of defense counsel, including undersigned, throughout the courthouse through security cameras for no permissible purpose and without cause. The state has repeatedly demanded reciprocal discovery from the defense without any legal basis and has repeatedly misstated the law concerning reciprocal discovery, all to obtain an unfair advantage from Judge Glanville. Look, another mistyping. Instead of judge, they put Judah egg. The state has gone so far as to contact non-attorney members of the defense team and demand that they provide certain items to the state without consulting the defense counsel first. These actions were taken without any legal basis and were attempt to unconstitutionally invade the attorney-client privilege and the duty of confidentiality of the defense. Okay. The state intentionally and erroneously accused Steele of tampering with and altering jail calls made by Kenneth Copeland, which were served in reciprocal discovery. Of course, these heavy accusations were entirely false and without merit. There were no consequences for making these wild, false claims. Okay, they keep going, and I'm gonna just go straight to the. Now, we can read this part about the ex parte on June 7th, and then I'll go read about June 7th ex parte. The defense, after repeated requests, has finally been provided with the state's June 7th, 2024 ex parte motion for order to compel testimony necessary to the public interest. This motion, submitted by the elected District Attorney Fonnie Willis and District Attorney Love, contains information and belief, a glaring misrepresentation. In paragraph 11 of the motion, The state asserts that after an encounter with the defense team members, right, Copeland informed representatives of the district attorney's office that he may attempt to plead the fifth in order to avoid testifying against members of YSL. The motion does not provide any information regarding the specifics of this alleged encounter of which the defense team members were allegedly involved. Upon information and belief, after reaching out to the defense counsels involved in the case, the information is completely false. Upon information and belief, no members of the defense had any contact with Kenneth Copeland on or about June 6, 2024. It goes without saying, upon information and belief, no defense counsel or members of any defense team ever contacted Kenneth Copeland in any way that would dissuade him from testifying. This false and disparaging information about defense counsel was provided to Judge Glanville in an ex parte meeting. Now, I'm not going to read the June 10th because we have read about June 10th forward, backwards, upward, downward. We're going to go straight to the part about June 7th. Let's go straight to, they had another crazy typo in here where they said 2017 instead of 2024. Now, if y'all have this motion in front of y'all, you go to page 10 at the bottom is where you'll find the June 7th part. What did it say? You should read June 10th. Why should I read June 10th? Tell me why. I went through it earlier, but tell me why I should read it now, and I'll consider that. The reason I'm asking is because I feel like we have gone through so much about that June 10th ex parte meeting, even reading the transcript verbatim. Is, just give me a good, just let me know why I should read it. On July 30th, 2024, the Honorable Judge Whitaker presided over substantive matters of this case for the first time. The Honorable Judge Whitaker provided, okay, I got you, Soleil. The Honorable Judge Whitaker provided much needed clarity to the defense by releasing a rough draft of transcript of additional ex parte communications between the prosecution and Judge Glanville. The ex parte meeting occurred on June 7, 2024, included Love, Hilton, and Glanville. These communications and substance thereof had never been disclosed to the defense until the Honorable Judge Whitaker released the transcript. Neither Judge Glanville nor the state ever made any disclosures regarding these communications, even as Attorney Steele pulled the curtain on the July 10, 2024 meeting. Instead, Judge Glanville and the state remained silent on the topic. Additionally, while the parties were well aware that the Honorable Judge Krause was considering the advisability and potential implication of June 10th, here it is right here, of June 10th, 2017, how in the world did you accidentally type 2017? As part of her consideration of motions filed to recuse Judge Glanville, upon information and belief, neither the prosecutors nor Judge Glanville ever revealed to Judge Krause that there was, in fact, another ex parte meeting that occurred 3 days prior. This was their secret. Now, the thing about, it's interesting. Okay. The transcript of the June 7th, 2024 communication is shocking. It also sheds light on how this case has become irretrievably broken. In an initial matter, there is no stated justification for the ex parte communication. The meeting was initiated by the state. Neither Copeland nor his counsel had requested that the state meet in private with Judge Glanville. The meeting itself was illegal. The state in this meeting intentionally and wrongly attacked the character of Copeland's attorney, Melnick, claiming that Melnick was not representing Copeland's best interests. The prosecutors besmirched Melnick to Judge Glanville without cause, all because Copeland was not interacting with the prosecutors in a manner that they would have preferred. The prosecutors claimed to be the only ones who were truly representing the interests of quote, our witness. The prosecutors complained that they had been having productive communications with Copeland outside the presence of Melnick before Mr. Melnick inserted himself in his client's legal affairs. The prosecutor's claims that Melnick was not representing Copeland's interests is rich. As they were communicating with the person behind Melnick's back, the state had intended to call Mr. Copeland as a witness without granting him some sort of legal protection as a witness. It was only after Melnick inserted himself and advocated for his client that the state sought to grant Copeland derivative use immunity. The irony does not end here, though. The state in this meeting claimed to be concerned about the possibility of Copeland suffering an unjust jail sentence due to Melnick's interference in his client's affairs. At no time, however, did the state ever seek any non-custodial alternatives for Copeland should Judge Glanville hold him in contempt. Instead, these prosecutors insisted on an indefinite incarceration for civil contempt, which would have been illegal. The state also questioned Melnick's devotion to his clients, as Mr. Melnick was planning to leave the state on vacation while his client was incarcerated for contempt. The state complained to Judge Glanville that Melnick had not planned his vacation around Copeland's testimony. This is a ridiculous accusation, and the state intentionally failed to communicate with Melnick and had not given Melnick any notice that they were planning to call his client to testify on June 7, 2024. The state was clearly only concerned with Copeland's interests. With Copeland's interests as long as they were directly aligned with their own interests. The state feigned interest in Copeland's well-being to get a foot in the door to Judge Glanville's chambers, all in an attempt to initiate improper ex parte communications. 23. Melnick was not only attorney who was disparaged by the state and Judge Glanville in the secret meeting. Love claimed that she was in receipt of an email from Melnick sent to her and Hilton, but that also other individuals had been blind copied on the communication. The clear insinuation from the conversation is that it was Attorney Still and undersigned counsel who were blind copied. So I've read, he was just saying that it wasn't a blind copy. Like, why would he blind copy us, pretty much? Judge Glanville abandons any impartiality and echoes Love's thoughts, asking, why would he have done that? Sick. I mean, he was cut off before 88 Hilton responds that the state's concern, and that's the state's concern. Love affirms. That's the point. That's from the rough transcript. As Judge Glanville had questions, so do I. Undersigned counsel asked why my inclusion on this simple email communication was of concern to the court. Love then assures Judge Glanville that she is looking for a remedy for this materially false and made-up situation as if one exists, and tells the Judge Glanville that she will contact him when she finds a solution, either over the weekend or on Monday, presumably through additional ex parte communication. Before wrapping up the illegal and unethical meeting, Judge Glanville refers to outside agitators affecting the trial, stating, but I see it from just being in the courtroom and tracking. Glanville's concerns and inherent skepticism of email communication between Melnick, Still, Schardt exemplifies Judge Glanville's bias and partiality towards the state. The transcript of both 7th and the 10th ex parte meeting shows Glanville's clear bias against Attorney Still, and undersigned counsel finally provided an explanation, albeit an unacceptable one, for Glanville's treatment of the defendants and the counsel throughout this trial. Okay. It's burning me, y'all. It's burning me up. It's burning me up. Hold on. Let's go to the remedies. Let's go to the remedies that we are seeking for Mr. Stillwell. Mr. Stillwell has been harmed by judicial misconduct, prosecutorial misconduct, and other errors in this case. Focusing solely on the ex parte communications, the prosecutor and the trial judge teamed up to coerce and intimidate Copeland to change his mind and testify for the state. Just crazy. Copeland's testimony was harmful in itself, but does more than that. As a result of this coercion and intimidation, the state has and plans to continue to impeach Copeland with his prior inconsistent statements, essentially playing several videos of Copeland's out-of-court statements, which are harmful and prejudicial to Mr. Stillwell and others. These out-of-court statements involve several of the charge of events and counts in this indictment, and are central to count 2 of this indictment, which alleges that Mr. Stillwell committed the murder of Donovan Thomas. Mr. Stillwell does not wish to demand a mistrial, absent a finding of goading and thus jeopardy attaching. Mr. Stillwell has been incarcerated throughout the duration of this case. He has been viciously attacked while incarcerated. He almost lost his life. Starting trial all over again is not a viable option for Mr. Stillwell. Despite the persistent legal errors, the illegal actions taken by the prosecutors and the previous trial judge, and the damage inflicted by the presentation of Copeland's prior untruthful out-of-court statements, the defense is winning. He said that in court the other day, too. Additionally, this trial has already been tainted by structural errors. Mr. Stillwell does not wish to submit to the desires of the state and Judge Glanville, who have attempted to goad Mr. Stillwell into moving for a mistrial. Mr. Stillwell does not want this case to start all over. Nonetheless, serious errors have tainted this trial. It is unacceptable that Stillwell must accept that the first several months of this trial have been tainted by prosecutorial and judicial misconduct, illegal ex parte meetings, and a partial judge. It is unacceptable that Copeland's out-of-court statements, which are arguably admissible as a result of the previous discussed illegal ex parte meetings, may be played for the jury. Wait, unacceptable? Should he have said inadmissible? I don't know. It is unacceptable that the previous rulings of a partial judge should continue to guide this case. Judge Glanville's hostility towards and suspicion of undersigned counsel has likely created a lasting impression on the jury, who surely view a trial judge as the person in authority. Carrying on with this trial as if nothing improper has occurred is not an acceptable option. The structural errors and other legal reversible errors in this case must be considered in the context of how they occurred. All of these errors have been caused by the prosecution and Judge Glanville. Neither Stillwell, undersigned counsel, nor any co-defendants or their counsel have caused or invited any of these issues. Hilton is a seasoned prosecutor of nearly 15 years who holds the title of Deputy District Attorney in the Fulton County District Attorney's Office. Per the District Attorney's website, she helped lead the Special Victims Division. She has been received many awards with the District Attorney's Office and also taught trial techniques classes at Emory University School of Law. Love is an attorney with almost 20 years of litigation experience, almost exclusively as a prosecutor. Attorney Love is a Chief Deputy District Attorney of the High Profile Cases and Difficult Witnesses Division within the Fulton County DA's office and part of the office's executive team. She leads a division in the largest DA's office in the state, one that is dedicated to cases involving difficult witnesses. Oh, I see them comment. I see them paragraphs y'all putting. I'm going to get to them. The Georgia Court of Appeals has noted that state prosecutors are generally knowledgeable and well-trained, too knowledgeable and well-trained to not know the consequences of basic rules of prosecutorial misconduct and procedure and conduct. Okay. Prosecutors as recognized and experienced as Hilton and Love should certainly be held to this minimum bar, if not much higher. Surely Hilton and Love, with their knowledge and experience, knew of the impropriety of those ex parte communications. Their experience told them something else, however. Based on their knowledge of the law of impeachment and prior inconsistent statements, the prosecutors knew that if Copeland did not testify and remained in jail, even a partial judge would be hard-pressed to allow the jurors to hear the multiple hours of Copeland's recorded statements. The ex parte meeting was a calculated risk for prosecutors. Either Copeland would be intimidated and coerced into testifying, or the illegal ex parte communications would be grounds for a mistrial, and the state would have time to regroup and begin anew. So this is why okay. Judge Glanville currently serves as the chief judge in Fulton County Superior Court. Per the Fulton County Superior Court website, he has been a lawyer for 37 years and served as a judge for 29 years, 19 of which as a Superior Court judge in Fulton County. Glanville knows the rules concerning ex parte communication, both in the Uniform Rules of Superior Court and Georgia Code of Judicial Conduct. Based on the experience of prosecutors Hilton and Love, as well as the experience of Judge Glanville, the notion that the decision to hold these repeated secret, illegal, and unethical ex parte meetings were due to inexperience or simple lapses in judgment does not pass any test. These were conscious decisions to secretly violate the most basic of Mr. Stillwell's constitutional rights. Several factors in this case, including the prosecutors and judges' wealth of experience, the egregiousness of the prosecutorial and judicial misconduct, the fact that the evidence presented so far has been far from overwhelming, the structural and reversible error already baked into this case, and the repeated violations of these rules all clearly support a finding that the actions were intentional and designed to goad a mistrial. Wow. Y'all mind if I read this conclusion? Real quick. The case is constitutionally and legally broken at this time. Mr. Stillwell is not requesting a mistrial absent a finding of goading, but appropriate remedies must exist. Possible remedies include, but are not limited to, the disqualification of the prosecutors involved in this misconduct. Glanville has already been recused. The dismissal of the indictment with prejudice. Instructions to the sitting jury that explains the situation in full candor, and or mistrial with finding that a mistrial caused by judicial and prosecutorial misconduct and the defense was goaded into any such request. Wow. Let me get back to the comments. Y'all. Let me get back to the comments. Let me get back to the comments. Hold on. All right. Hold on. Okay.